Thank you, Mr. Chairman, and thank you, Mr. Cordray, for your return again. I appreciate your collaboration with us in looking on this issue. I want to follow some of the issues that have been identified by some of my colleagues, because I too have been spending a significant amount of time back in my community talking with largely small business owners and small institutions, banks and credit unions, things that you have identified, if I'm correct in your testimony, as not really being outside or inside the scope of the problem, that a lot of the outliers, the non-bank kind of lending, participated in the creation of a lot of the problems. What I am concerned about is the regulation that now attempts to deal with the issue, reaching back and really affecting some of these institutions. Let us take as a point, I think, which would be consistent through most of these institutions. Many in my area, about 100 employees. Most of them probably maybe one compliance officer. I talked to one bank president. He is the compliance officer. And the fact of the matter is, you talk about the timing of the activities that are coming out. So this small bank, already they're dealing with the Basel requirements. There was documentation that went out to these small bankers, 250 pages of documentation, which identifies what they must do within their small institutions with regard to retention of capital. Then in the same month of June, we had the qualifications that came out for what is a qualified mortgage. This was something small banks have been doing for years. The paperwork that identified what a small has been put in the Federal Register, it's about 115 pages. That, again, all of the fine print, what concerns me is that's 150 pages with that kind of fine print. It looks to me like a litigator's dream to begin to try to codify all the things that bankers have been doing for years. But the real concern that I had in talking with my small community bankers was, we took the 10 pages that were part of the Truth in Lending Act and the Real Estate Settlement Procedures Act, and I understand the implications of trying to make it simpler for the buyer. But in the act of creating what it means to take 10 pages now, and we've reduced it to 8 pages so that the borrower can understand what's before him. But for the banker, this right here, 1,099 pages of regulations, 1,099 pages that one single compliance officer is going to have to go through to understand what it means to be able to interpret a document which has been in existence, the Real Estate Procedures Act, for years and interpreted many times by the law. It's not the document, it has been the abuse of the document. How are we going to take into impact, trying to draw a distinction so that these small community bankers aren't pulled into the overregulation and a problem and an effect in which I'm concerned we're going to drive the ability of these small banks to continue to service the community. I'll ask my question when I just give you one other observation. One of the bankers that I talked with was discussing the fact that when you have 100 people, you're very tight with regard to what you can task each to do. There was enough cash on hand to consider 1 or 2 new employees in the coming year. Do they hire lending agents that can go out in the community and negotiate loans, or do they hire compliance people? In both cases, it was compliance people. We are spending money on oversight, particularly in institutions. Now, so institutions that may not need the same degree of oversight as those who were the abusers in the process. Can you tell me how we're going to approach the ability to try to be fair and effective in the engagement with the small community banks so as not to dry up the very objective of creating credit in the first place?
So I appreciate the question, Congressman. I appreciate the chance to address what I think has been much misunderstood about the rule that merges the Truth in Lending Act and Real Estate Settlement Procedures Act forms, which is something, by the way, Congress has been complaining about for 20 years. They wanted those forms integrated. They wanted them simplified. It's actually much more than 10 pages to 8 when you see the other things we're dealing with that go into that. But it's something that is now being accomplished by the Bureau for the first time in 20 years, after 20 years of failure. But the notion that there's a 1,099-page rule is not a correct statement of fact. Much of what's in that rule involves detailing the efforts the Bureau has made to reach out to smaller institutions, Sabrifa panel, and so forth. Much of it is detailing the cost-benefit analysis. Much of it is providing what industry tells us they want, which is some detailed guidance. It's not the rule itself, but it's additional guidance on how you can comply with the rule. So it feels to me that you can't, one and the same time, complain that the Bureau doesn't engage in sufficient extensive cost-benefit analysis, and then complain when we devote a lot of pages in our proposal to the cost-benefit analysis that you've told us that you want. It doesn't feel right to complain that the Bureau doesn't do enough outreach to small institutions, and then complain when we do the outreach and it actually results in a lot of summarizing in the proposal that actually we have done that.
So is this guidance then that is going to be directed to the small community bankers going to have to look at this and interpret the 1,099 pages to be able to determine what the terms of that Real Estate Settlement Procedures Act document mean?
Well, they've had extensive input into the forms, which are
What's the purpose of this? What will the small community banker do with this document? Because we know with 1,099 pages, there is an expectation, or at least litigators will expect there's an expectation, that they have read and reviewed and understand the implications of every term within it.
But only a small portion of that is the actual rule. Much of it is the kind of explanation, procedure, detail, analysis that Congress has told us they want to require before we can write a rule. So when we go and do all of that detailed analysis and present it, cost-benefit analysis, I don't think that a small bank has to be conversant with our cost-benefit analysis, but it's something that's required of us to justify the rule. Again, to complain that the agency needs to be very careful and thorough in its process of developing the proposals for rules, and this is a proposal, it's not the final rule, and then to complain because all of that amounts to a lot of pages. You know, you can't have it both ways. Also, we're told over and over again by industry that they prefer specificity. They don't want us to write a short rule. It's kind of counterintuitive for me. They don't want us to write a short rule where there's lots of things that have to be interpreted and going into the courts and have to be interpreted how? Through litigation, through hiring lawyers and having them, bring cases that obviously
But
takes years.
I don't want to step on your explanation because I appreciate this, and I do think and I know my time is up, but as an attorney, my concern is it's just this which will create more litigation because you know yourself as a former government attorney, the ability to look at specific cases and then find distinctions and ask why we didn't apply, those particular circumstances to the decision was made creates a litigator's dream.
Again, a short rule that's general and vague will leave a lot of things mushy, and there will be a lot of things that will have to be litigated because it's the only way you can get things resolved. Industry tells us they want us to avoid that. They want us to be very specific. Specificity often means greater length. It's a dilemma, it's a challenge, it's something that we're working through, but we're trying to work it through, I want to stress, with a lot of input from the small providers you're talking about, thinking about how these rules affect them, thinking about when we can impose exemptions or thresholds. Ultimately, you were a referee, right?
Right.
Ultimately, we do the best we can. We have to make a call. People are going to criticize us on both sides of it. Were we too thorough and therefore too long? Were we not thorough enough and therefore subject to challenge on that front? But,
Gentleman's time's
we will
expired.
take this input back, and it's something we wrestle with every day. So.
Thank you.